So I don't want to trespass on the time, but my Lord Lord Justice Lewison, before the short adjournment, said he thought that there was a county court case about the 54 Act which might be relevant.
Yeah, that was the one I was thinking of.
My learned friend, it's not me, it's my learned junior, Mr. Sadiq, who should take credit, who's found it, and there's also a second case, Thomas and Van Staden, which is behind it, which refers to it. And those cases do use the word nullity, and indeed the Nichols case distinguishes Isaacs and Robertson on the basis that the county court has limited jurisdiction.
Yeah, that was my memory of it.
Good. My Lord, very briefly on that in response.
Yes, thank you.
In Nelson and Clear Springs, which is at tab 19 and page 977, paragraph 50, which is at D to G.
So 9. Which page, sorry? I'm sorry.
It's page 977.
Paragraph 50, yes.
Now, I accept that this only goes so far, but it deals with an irregular judgment where the proceedings were not served. And it says in paragraph 50, that's not to say there's not an application to set a judgment in a case of this kind. The just order would not always be to set aside the judgment. In the case where the proceedings have not been served on the defendant, the service has not been dispensed with before judgment, a court could only properly refuse to set aside the judgment where there is no prejudice to the defendant or possibly to some innocent third party who has acted to his detriment in the belief that the judgment was regularly entered. And so, though there is arguably a distinction to be made between irregular judgment and one which was made on my learned friend's argument out with the court's jurisdiction, they are both in my submission species of irregular judgment, and Nelson is support for the proposition that I made before the lunch adjournment, that even if it is a nullity, it doesn't then follow that the court has to set it aside. And they can take into account the effect on an innocent third party, which in this case would be the effect on the purchaser without notice of the new lease created by the appellant. My Lord, I now turn to the appellant's ground of appeal.
Yes, thank you.
And, my Lord, I believe I can keep this quite short and pithy, I hope. It's on the basis that success for the purposes of 39.5 does not include relief from forfeiture. And for that I turn back to the starting position that I've mentioned before, which is Lord Justice Lewison's citing with approval of Lord Justice Parker in Bilson and Residential Apartments, with the statement that relief against forfeiture is now regulated wholly and exclusively by statute. I attribute no other meaning to the words taken over. So,
Sorry, just give us the reference again. I don't need to look it up, but just give us the reference. Tab what?
it's paragraph 55,
The Vulnerable Authorities tab number.
and it's 29.
And it's paragraph
47.
Thank you.
Where does that get you on this point?
That gets us to the point that this is not, in terms of section 1383, however that's read,
Yeah.
but for the sake of the argument at this point, well, I take it as it's read as is, as if it had been a trial. But for the purpose of section 1383, once the order is made, then there is no discretion on the court. The court makes that form of order. It's not that relief from forfeiture, as it may have been done historically, is raised as a defence or counterclaim. It is not. The historic background to forfeiture was an equitable discretion, but now it's been subsumed entirely in the county court in rent-only cases to a statutory regime. It's no longer an exercise of the court's discretion. It is the order as made. Now, if for one moment we were to assume, and for this purposes, that the order had been made in the section 1383 form, so in fact the 4 weeks had been given and the order could not in any way be impugned, then the effect of my learned friend submissions would be that they wanted the court to set aside the order for the court to then remake the exact same order. So clearly, as I stated earlier, in terms of substantive defences, so in terms of defences of waiver, of non-service of the proceedings, etc., those would be a substantive defence of which the court could take the view, does the defendant have a reasonable prospect of success or not, and that wouldn't produce any problem at all. But in terms of the order that's made under section 1383, the court does not have a choice. The court makes exactly that order. It is not an exercise of discretion. And given that it is common ground that forfeiture, in terms of non-payment of rent, is a form of enforcement, that the whole purpose of bringing a possession action under 55 is not, in my submission, to necessarily obtain possession, but is to enforce the landlord's right to the unpaid rent. It is a method of enforcement.
Well, it might be said that if you look at the claim form, what you're claiming is possession, not possession unless the tenant pays up within 4 weeks. And if an order were to be made under section 1383, you would not be getting what you claimed. Therefore, you didn't have success in what you were claiming.
Well, except, my lord, in my submission, you would be getting what you claimed, because you would be getting an order of full possession, as set out in the claim form, but not to be enforced for, or not to take effect for a period of 4 weeks.
Well, you weren't claiming an order which didn't take effect for 4 weeks.
Well, except if my learned friend's argument is right, that would be the only order that the court could ever make.
Mm.
And so it would, in effect, open up the floodgates that any defendant who didn't turn up, you wouldn't have to, if this is a Findlay case and not a Forcelex case, then any tenant who didn't turn up, as long as they could give a good reason and had made the application promptly, would automatically have the order set aside.
Is anything particularly wrong with that?
Well, it would in effect take away the discretionary element which is afforded to the court in looking at...
You're way ahead of me, I'm sorry. I'm way behind you. Can we just... The question we're now addressing is for the purpose of the rules now we're dealing with, aren't we? What is a success, is that right?
Yes.
And we're now looking at, let's just get where we're looking at. We're now looking at which page in the white paper. Or you've actually put it in the authority, haven't you?
We're now looking at
We're now looking at
39
39.35, which you've got at 24.
yes.
And so the question is, has a reasonable prospect of success at the trial, all right? That's if the judgment is set aside. Now, just trying to understand this point, you're making a point, and I'm not sure that because I'm being slow about it, that you have to make an order if you're within 1383, 1383, you have to make an order in the terms they're specified, and there's no discretion.
Yes.
What has that got to do with this issue?
Because it's to distinguish between the order which is made under section 1383 and an order or a situation where you'd look at success at trial where you had a genuine defence. So any landlord applying for forfeiture under section 1383,
The trial here has a reasonable process at the, it has, we're looking prospectively, the case is
Yes.
established here. We're now looking not at the past, we're looking to the future. So if the order is set aside, you have a reasonable prospect of success at the trial, and we're not dealing with the meaning of trial, we're assuming that it means when you go back, when to meet the landlord's application for possession.
yes,
Right. So we're going back now. The claim form says arrears of rent. Not that this is this case, but presumably it says arrears of rent. I want possession, and I want the arrears of rent. That's what I want in my order.
yes,
Right. Okay, that's fine. You then say, and the defence is all sorts of substantive defence. You didn't serve it properly, etc., etc., etc. I'm happy to pay the money at least within the 4 weeks or whatever the period is. Or straight away, I don't know. I think she actually paid it all, hasn't she? She's offered it all. She's offered it all. So she's in a position, sorry, he, not she. He's in a position to pay it all. So he's having to pay all the arrears, and so the landlord, we've now passed the return date, I assume. So you can't get under 1382. So it has to be 1383. Why is not saying, right, I'm happy to pay the money and you won't get possession? You're saying that's not a success.
No, because whether you're happy to pay the money or not makes no difference to the order made. You don't have to turn up to the hearing and say, I'm happy to pay the money. The order, if it was made under section 1383, would have to be possession to take effect within 4 weeks or longer. That doesn't depend upon the tenant saying, I have the ability to pay. It is an automatic function of the court. There's no discretion to the court. This is part of the whole nullity argument that my learned friend put forward. There's no discretion afforded to the court. So how that can be properly characterised as success when a landlord has applied and has got the only order they could ever have, being a section 1383 order. And given that time and time again, the courts have said that the whole purpose of forfeiture for non-payment of rent is actually a form of enforcement.
Haven't you got to look at the position as it is now, and the position it would be if they were allowed to go back and argue together? At the moment, there is an order. At the moment, the position is subject to the point you just heard this morning. At the moment, there's an order for possession. If you go back and you're allowed to open it up again, that order, you'll say, well, I'll pay it, so you can't get possession. So from your perspective, the possession of the tenant is, they're entitled to remain there. I mean, I don't understand why is that. You've failed if you want on one part, which is you have to pay the money, but you succeed on the other part in that an order for possession isn't made. Why is that not from a practical point of view, you're allowed to keep your property.
But the order for possession is made. So if you put aside the nullity point, and we were here, and the order that had been made fully used the same wording as section 1383.
Why will an order for possession be made if before the hearing, the substantive hearing, the tenant proffers the full amount of what's due? The court's not going to make an order for possession.
But that's the only order that the court can make.
Why? And if the tenant has paid the full amount, or tendered it all, the full amount, why is the court bound to make an order for possession?
Because the tenant can, under 1382, pay the full amount 5 days before the return day. Then, at the...
All 1383 says if you make an order for possession, it has to be on terms which enable the tenant at least 4 weeks to pay. That's not the same as saying you have to make an order for possession. That's a different point. You can look at 1383. 1383 is designed to give the tenant, even when an order for possession is made, the opportunity of paying off, isn't it? Or I got that completely wrong.
At least Mr. Rayleigh's skeleton argument says that the question that we have to decide is whether being able to have an order set aside but replaced by an identical order with different dates in order to obtain relief is a success. I don't think, in your favour, I don't think he's saying that he's entitled to anything better when he goes back than a 1383 order.
And that...
But I'm taking my law's point though, if that's what the court can do, and the chap turns up with a banker's draft for whatever it may be on the order, it does seem rather silly to make an order of that sort.
1383b says, if the court at the trial is satisfied, the lessor is entitled to enforce the right of re-entry or of forfeiture. Well, if you've tendered the rent, why should you be entitled to enforce the right of re-entry or forfeiture? You might have been entitled in the past, but why should you? Anyway, the point's not taken, is that right? Mr. Rain, they were not taking that point.
About whether or not it depends when you tendered it.
Well, the point is, if it goes back now, you have the opportunity of tendering the rent.
Yes, we would have the opportunity of tendering the rent. I suppose I hadn't addressed my mind to the fact that if we simply paid it all over and could agree all the costs and so on, you're probably right, the court wouldn't make an order at all.
Well, it might be an order for payment. Anyway, all right, let's just leave it. Maybe I've taken a point that should have been taken, and as my lord said, I think at the moment the way it's put is, yes, we'll have the opportunity of paying the money at new dates.
And that, my lord, in my submission, undermines the statutory purpose of section 138, because you then have under 1389, which is at tab 20 and the second page, where the lessor recovers possession of land at any time after the making of the order under subsection 3, whether as a result of the enforcement of the order or otherwise, the lessee may, at any time within 6 months from the date on which the lessor recovers possession, apply to the court for relief, and on any such application the court may, if it thinks fit, grant the lessee such relief subject to such terms and conditions as it thinks fit. So, in effect, and when one looks at the Finley case as a useful contrast, in Finley, under the Housing Act, you didn't have the 9A provision. In Finley, the court didn't say you should be put back in the position where you get relief from forfeiture as of right, that the possession order is set aside as of right. It actually said that the court would have to exercise its discretion and look at factors such as had a new lease been granted somewhere else to a third party. In effect, the court has recreated in Finley, for the Housing Act, the very provisions of section 1389A, the exercise of the court's discretion over forfeiture. So the two logical inconsistencies here are that they're using, or they were originally using the Finley case to import back into a case which was section 1389A, the section 1389A regime. That is the effect of His Honour Judge Luber's decision, and the reason why he remitted it back to the county court to consider whether, in all the circumstances, the order should actually be set aside. But by the same token, when you are applying to the court as a landlord and you're seeking a forfeiture for non-payment of rent, if that is the only order that the court can make, if the tenant has not paid beforehand, and they're given their cut-off dates, so 5 days before, you take it automatically. After that, then if there's been a trial, whatever that is within the meaning of the Act, you're then given a further month. But that order does not change. There's no discretion over how it's made. That order is the only order the landlord can obtain. So the landlord will have achieved the maximum amount of success that they could have achieved, especially when the purpose is enforcement. A landlord is not usually expecting a tenant not to pay the rent in order to avoid the enforcement. So, in my submission, that cannot be characterised as success or success of a defence, because it's not a defence. It's an automatic function. And to equate a automatic function, a statutory function, not relief from forfeiture. My learned friend's submission keeps on mixing up the relief from forfeiture. It is no longer relief from forfeiture. It doesn't even comply with the traditional rules of relief from forfeiture. Traditionally, a judge at the return date, if they'd made a forfeiture order, would be considering a balancing exercise. Should I or should I not give the tenant relief? Here, it is an automatic statutory function. It is a creature of statute, and it is limited to that statute. So to say that in some way it is a success, in my submission, is wholly wrong. And this would be an instance in which the court would be circumventing and undermining the statutory regime, in my submission, by use of the CPR.
That would suggest, would it not, that the Croydon unique case is wrong? Because in that case, as we've been shown, it was accepted that there could not have been an application under section 1389A because it was out of time. So that must be wrong, isn't it, on this argument?
The Croydon unique case, my lord, I've focused on the nullity point on. In terms of the 9A,
As Sir Christopher said, it shall go back and they'd have the order set aside, even though they were out of time for applying for relief under subsection 9A. And we saw that from the argument that Mr. Tevison advanced. So if this part of your argument is right, then the Court of Appeal's decision was wrong.
my lord, in that circumstance, there hadn't been any opportunity given to the chargee.
Well, that may be so, but your general argument on this point about undermining the statutory code is that if an opportunity is there under subsection 9A, then it is wrong to set aside an order under subsection 3.
My lord,
possession has been recovered.
My lord, in my submission,
as I understood it, that's the submission you're making.
my lord, in my submission, it can be distinguished from this case,
Right.
in respect of they were concerned with section 1389A and the discretionary relief that would be available, and not section 1383 and the automatic provision of relief where there is no discretion. And our big grumble, if I may put it colloquially,
Sorry, let me just follow that one through. So, you say that the chargees could not have taken the benefit of 1383 because they don't fall within the definition of lessee. Well, that includes a person derived from title under a lessee, according to section 140. Subsection 9A applies where the lessor recovers possession, and 9C allows the person with an interest to make the application under 9A, that is, once possession has been
Yes.
taken. And none of that is to do with setting aside the order originally made under 1383,
exactly.
which is what the court said should happen. So it seems to be inconsistent with your argument.
Well, my lord, in my respectful submission to the court's decision in that case, that what they were looking at was the effect of section 1389A without turning their attention to actually what would happen by setting aside section 1383 and also in that case they had the confidence of the service point as well. Sorry, they had the point of the nullity argument as well. And so because it wasn't looked at in this way, and I can't see that they were addressed at it in this way, whether or not they'd considered that aspect, and therefore in my submission it can be distinguished, which gives...
Go back to my point. Why is it not on the evidence that we had before? If you apply to, in this sort of case, to set aside the existing order for possession, you are given the opportunity of doing a number of things. One, at any time before the trial takes place, you can seek to pay off what is due. You can raise the money. You have that opportunity to do so. If you don't do so at the hearing itself, you can argue for a period of longer than 4 weeks. I assume, is this right, that you can also attach to it perhaps particular methods of payment. I may be wrong about that. Maybe I'm confusing that with the Housing Act. Anyway, but you can apply for more time. You've got a number of courses that are open to you to avoid possession. In the present case, the evidence, which as I understand is unchallenged, but correct me if I'm wrong, the tenant did at least at one stage have, the tenant here, the applicant here, did at one stage have enough money to pay off what was due and profited, as I understand it, but it was refused.
no, my lord, that's wrong.
He never offered it.
No, the tenant in the set-aside application, the solicitor for the tenant said that she was ready, willing and able to pay. There's never been a tender, and that's never been
That's the
refused.
evidence, that's the evidence. I didn't know that, but that's fine. But that's the evidence. If we are satisfied, and it's a reasonable prospect of success, it has to be, if the evidence remains as it is at the moment, that he was given this money, and he can pay it off, or at least he'll have the opportunity to do so, I don't understand why that opportunity shouldn't be taken into account as to what it might well happen at the trial itself. Why do we have to ignore that possibility as a matter of reality?
Well, because there wouldn't be a trial.
It might be. Why do you say there wouldn't be a trial?
Because if before this appeal and the additional arguments weren't mounted, so the whole point of this was in a situation where the appellant, or the hypothesis is the appellant hadn't paid the rent, but had no other defence. If the appellant had another defence, then this whole question wouldn't arise.
It's not a defence. Just looking at the reality of the situation. You've got a tenant against whom there's been an order for possession. He's failed to meet it. There are all sorts of reasons why he either was culpable or not culpable. There's a waiver, there's service, all these other issues. We're not going into those. But one thing is definitely true, which is if he didn't know of the proceedings, he had no opportunity to pay off the rent. The evidence now is that he has been given the money to do so. In deciding whether or not there's a likely success at the trial, why should the court ignore that possibility? Why should we ignore that possibility?
Because the court, in my submission, would be stretching the meaning of success in that the court would, in effect, be setting aside the order merely for exactly the same order to be made again.
Well, it might or might not. But I said to you, we're dealing with a situation here where let's assume slightly different facts. The tenant has always been in a position and always been willing to pay the money. The tenant's abroad, doesn't hear about the case for whatever reason, and the order for possession is made and is executed. The tenant then finds out, whether 6 months later or after 6 months later, that the order's been made and applies for it to be set aside. Is it really right that the court, applying, if the correct thing is to apply by analogy the provisions of the CPR that we're talking about, 39.3.5, is it really the case that the court has to ignore the reality of the fact that the tenant always has been and now is in a position to pay the money? That's what effectively you're saying. Can that possibly be right?
Yes, because under section 1389A, the tenant can make that application still for relief on the basis that they are willing and able to pay all of the rent and all of the costs. But the court then has a residual discretion. So the only purpose of applying before the expiry of the time
after the 6 months.
After the 6 months, you then have finality. But the intention of Parliament was quite clear, was to give finality. One cannot ignore Section 139, and under Section 139,
So you see, after the 6 months, there's no right to recourse under whatever it is, CPR 3 point whatever.
yes. So if a landlord just goes in under peaceful re-entry, then after 6 months, that's it.
Well, that's not necessarily going to tell us what reasonable prospect of success at the trial means, which is, as I understood it, what we are now considering. What has to be shown under 39.3.5 is a reasonable prospect of success at the trial. Just contrasting that with the wording under Part 24, where the court gives summary judgment if the defendant has no real prospect of successfully defending the claim. Now, success at the trial might be slightly broader than no real prospect of successfully defending the claim, might it not?
Well, especially as at a trial, they could bring a counterclaim. So in the normal way, one would bring, if it wasn't a Rent Act case, there would be a counterclaim for relief from forfeiture.
Right, so
And then-
success at the trial can include success on a counterclaim.
I would accept that, yes. But there is a discretionary element. There is an element where the tenant may not even be ordered or given relief, or they may be given relief under very stringent circumstances.
And when we've looked at the case so far and what is the success for the tenant, I suppose you're saying, well, the only success that you could get in a possession claim based on forfeiture for non-payment of rent is a Section 1383 order.
Absolutely.
And ergo, you've succeeded too on that basis.
We've
You've succeeded all you could hope to achieve, although Mr. Rainey's client would be given the window to pay in the 4 weeks or such longer period as the court granted.
And
To that extent, you didn't get a possession order, but under 1383, you would say, well, I've done as well as I ever could do, and therefore I've succeeded.
and if
that
it,
right? Is that
yes,
right? Yeah.
that's absolutely right, my lord. But also,
That's right.
it's the situation where if we were dealing with a 1383 order and there was no question about the regularity of the order, then all you would be able to do would be to set aside the order for the court below to make exactly the same order.
So can I just pursue your point that success can include success on counterclaim? So I'm a landlord, I wanted to forfeit, not for non-payment of rent, but for breach of covenant, subletting, let's say, or use covenant. I serve a section 146 notice, get my order, tenant's not there, he can apply under 39.3.5 saying, I've got a good counterclaim for relief against forfeiture. It's discretionary, it's true, but I've got good prospects of success in that, and that counts as success at trial.
Because there would be a trial.
Right. So it's only because we're in the statutory code under 138 for non-payment of rent that you can't make this application.
Yes, because
So if service charges, for instance, were not reserved as rent, you could, but if they are reserved as rent, you can't.
well, except under service charges not reserved as rent, one can't see a situation in which there would be a genuine defence. If there had been a determination that the service charges were due,
Yeah, but
by the
there'd be a
FTT.
claim for relief. There'd be a claim for relief, which is not within section 138, which I understand you accept could count as success at trial for the purposes of 39.3.5.
but in
You
those
said that.
yes, but in those circumstances, I cannot see in that hypothetical, I can't see a situation in which a landlord would oppose relief from forfeiture.
Well, that's maybe, but you're saying that if the service charges are reserved as rent, then there is no possibility under CPR 39.3 of making the application under 7.5. But if they are not reserved as rent, then you can make that application.
Yes, and part of that is down to the fact that the landlord is in a normal section 146 service charge case.
And that, you say, is a perfectly rational interpretation of 39.3.5.
Because there would be an exercise of the court's discretion, and there would be something for the court to determine. Whereas, as here, it effectively cuts both ways, because here, the landlord, if it's a 1383, they'll have the order made as is. There's no discretion as to how it's worded or what provisions are applied. And so if the court is being asked to make exactly the same order again, the only purpose of the court, because it's an entirely statutory regime.
Yeah.
And so the court is asking for it to be made again. The only purpose is to reset the clock.
Yes, but you're resetting the clock in a way that will now enable you to avoid possession.
But then that does severe prejudice to the landlord, because you're resetting the clock after they've relied upon the order, and you're making the relief mandatory. If they pay, nothing else gets considered. And even His Honour Judge Luber hadn't accepted that, and neither had the court in Findlay. In Findlay, they still accepted that you would have to go back and look at questions like, has a new lease been granted? It would become discretionary, not mandatory. And if it becomes discretionary, what we're descending into, in my submission, if this is deemed to be success, is the very thing of how many angels are on a pinhead, because rather than making it 1389A, where the court could look at all the factors and then make a fair decision as to whether or not there should be relief from forfeiture, the only purpose of this is to get that mandatory relief, is to take the discretion out of the hands of the court. And in my submission, that cannot be right. And in terms of dealing with the overriding objective, that cannot be right. It tips the balance too far in favour of the tenant. And also, my lord, it does come back, and one can't ignore Section 139, and one can't ignore the fact that whatever the intention of the tenant, she was leaving these premises empty for a considerable period of time, which meant that the landlord could have proceeded under Section 139. If the landlord had said, I'm not going to have any sanction from the court at all, I'm just going to peacefully re-enter, which they could well have done and perhaps should have done when they went in and changed the locks. If they'd said, we've peaceably re-entered.
Can you do that if you have to break the, can you do that? Is that peaceable re-entry when you have to take the locks out?
Yes, it is, my lord. It's only Protection from Eviction Act if there's someone in occupation. There's nothing stopping the landlord.
What about occupation? You go on holiday for a week. The landlord takes his time then. Oh, he's gone on holiday. I mean, is that forcible entry?
Yes, I believe so, my lord.
Well, where's the line drawn then?
Well, my lord, that's a matter of fact and degree.
Whether somebody is still lawfully residing.
Yes. Where no one was actually, and it's not even contended that she was residing there.
I get you.
None of her things were there. It was.
Mr. Rain is shaking his head. I see.
Yeah. So they could have gone in, and then there would be no discretion at all in 6 months. And the court is effectively, in this situation, this scenario, only really arises in that sort of situation where a landlord has elected proceedings rather than peaceful re-entry. And the effect of this decision by your lordships could be to in effect, encourage landlords to risk peaceful re-entry more frequently, because then if the tenant is not residing there, they can be there for the 6 months and that's it. All they have to do is nail something onto the door and say, I forfeited by peaceful re-entry, and go in. There's no requirement to write to the tenant or inform them in any other way that you've done that peaceful re-entry. But Parliament decided that in those circumstances there would be finality. And in the same way with 1389A, there is finality, given that it's 6 months after possession is actually taken. And to then reset the clock on this artificial guise that resetting the clock is success, because then the tenant could avail themselves of a right that has now lapsed through time on a regular judgment, in my submission, undermines the parliamentary regime and should not be countenanced. And
it undermines it because of 9A.
yes.
But 9A only applies when there's been an order under 1383, which complies with 1383.
My lord, that goes to the nullity point.
No, I mean, we're now proceeding on the basis that it's not a nullity.
Yes.
Because you're right.
Which is that it was regular, and whether that be regular in the way in which I say it should be regular.
If it, 9A only applies after the making of an order under 1383.
Yes.
If no order has been made under 1383, then 9A can't apply.
On the way in which it's worded, and following the logical argument, no, it can't apply.
So
But
138, on your argument, 1389A has got nothing to do with it.
save that some meaning has to be given to the provisions.
Well, but it's part of a code which presupposes that an order has been made in the form required by section 1383. Isn't it?
Well, my lord, with the danger of trespassing back on the nullity points that
Yes.
we were
And
discussing earlier.
I thought the position was that you accept that if you lose on the point that was argued this morning, then either it's a complete nullity or it must be set aside as irregular, subject to your discretion.
Yes.
So if that happens, one way or the other, assuming you fail on the discretion point, risk of taking. If you succeed on the discretion point, then all these points can be considered. But if you fail on the discretion point, then the order itself is either nullity or it's set aside. In either case, where the clock is set back, you must accept that.
It's set back, or if you were to under the slip rule, deem that, or under the slip rule say that the 4 weeks have been allowed because it made no difference.
Anyway, all right. Let's assume, ignore the slip rule for the moment. Let's assume it's set back. We don't get into this argument. So all these other points we're now raising on your appeal, I thought were proceeding on the basis that you had succeeded in your argument in saying that trial means what it says under 1383. There hasn't been a trial, and so the order is a regular order. Is that right?
Yes, that's my primary.
That's your primary point. Now, where do we get to the situation where we're now in?
If you find that the order was a nullity,
Yes.
and you're with my learned friend that it should have complied with section 1383, then that still raises the question for which the permission to appeal was given in the first place, and may have an impact on submissions on costs later, as to what is the meaning of success. Is that the ability to, without any other defence, reset the clock
Yeah.
back to the start?
And your point, as I understand it, is that the order under section 1383 is the only order the court can make, or the most favourable order the court can make to your client in the case. It's automatic, there's no discretion. That's what differentiates it from a case where there's a counterclaim for discretionary relief against forfeiture. And in those circumstances, the mere fact that the court does what it's got to do can't be counted as success from the perspective of the tenant.
Absolutely.
Yeah.
And the absurdity of which was accepted by His Honour Judge Luber and is what happened in Findlay was where they actually recreated the 1389A. It wasn't a case of them saying we're going to set the clock back so you get an automatic relief from forfeiture.
So I'm still behind. My lord's ahead of me. If you fail on your first point, and Mr. Rainey succeeds on that, well, why we're not within the territory anymore of 3935. The order is simply ineffective, or it's set aside. You don't need permission to set it aside. We don't need permission to go back to trial. It's finished. Why I don't understand why we're in 3935 at all in those circumstances. The court simply makes a declaration, whatever it may be, that the order was a nullity. That's it.
Yes, my lord, but it does have an important effect on the costs.
Well, that may be, but I'm trying to understand how 3935. If you lose on the first point, then the court will make an order effectively saying I think the way it would work is that your appeal fails, and presumably I don't know how the order would work, but we would make the declaration or some order confirming that it was made without jurisdiction. Probably say it was made without jurisdiction, and either would say it's a nullity or it's entitled to be set aside as of right. Why are we in 39.3.5 in those circumstances?
In those circumstances, we wouldn't be in 39.3.5.
Right, that's fine.
And that comes down to the point I raised with Nelson that I asked the court to look at.
Right,
As
so
to-
don't go ahead.
Yeah.
Just stay with me for the minute, if you will, before we go on to something else. So that deals with the situation if you've lost on the first point. If you've won on the first point, then if you've won on the first point, then the position is that the order is a regular order of the court, even though it didn't comply with 138.3. And that's at that point you're saying, so if you win on that point, you're saying we're then back within 39.3.5.
Yes.
That's the point we are. So that's what you said. That's where we were when the appeal was launched.
Absolutely.
Right. I see.
And if we are, that then raises two different scenarios. So, if you are with me that the order isn't a nullity, and we're into 39.
Can I just pause there? So the contrast we're now making is between an order which made no provision at all, a regular order of the court which made no provision at all for the payment of costs by the tenant, of the payment of what was due by the tenant within 4 weeks or whatever it may be. So that order, the argument would be at the trial, the tenant would be saying, no, you're not entitled to that order, although it's a regular order of the court. What you are entitled to at most is an order that I be allowed up to 4 weeks or more to pay. So that's going to be the issue at the trial. Why isn't that going to be a success? If the result of going back is to say to the court, no, instead of the order which the landlord wants and which it has obtained, which is one for payment without any opportunity for me to pay off the rent, I want to have, and I'm entitled to have, an order which allows that. Why is that not a success?
Well, if you're with me on the fact that 1383 doesn't apply, then the order made of the court then doesn't have a discretion to order 4
It
weeks.
doesn't apply because of the trial point.
Well, there would be no trial. If you're with me on section, on the section,
If you won on the first point, that means
So-
we've accepted.
so that means you've
Trial is not
accepted that the 4 weeks aren't required in circumstances where the order is made under CPR 55.8.
In which case relief is not automatic.
In which case there is no relief.
There's no possibility of relief.
There's no
So
possibility
that's
of relief.
your first point. That's your real point one.
That's my point one.
There's no possibility of relief.
Now, I don't
Either automatic or discretionary.
either automatic or discretionary because none is afforded by the statute.
Yeah.
Now, I don't need to go as far as that.
No, you can go into that. If you succeed on the jurisdiction point, then no trial within section 1383, and therefore no possibility of relief of any kind because not catered for by the statutory scheme.
Well, my lord, if I may qualify that, the arguments in relation to section 1383 not applying are based upon the wording which, whether it be because of defective drafting or whether it be that when the CPR was created and CPR 55.8 was created, the rulemakers hadn't turned their minds to the impact that would have on the wording of section 1383. All I need to show is that that was a regular judgment and that when there is no defence, no genuine defence, that the 4-week period doesn't then apply. I acknowledge that if you then follow that logic,
I'm sorry, you're putting these things in a really complicated way, and I don't think they need to be put in such a complicated way. We're assuming for the moment you've won on the first point, and the first point turns, as I understand it, what is a trial?
yes,
Otherwise, I've misunderstood everything you said this morning.
no. But the point I also made this morning was that my lordship raised this point and it was addressed, was that then has a whole series of unfortunate consequences,
Yes.
and ones where, in effect, the rest of the provisions
Yes. No application.
become arguably have no application.
But that was your case.
Yeah, but the point, the case is to argue that Section 1383 doesn't bite. The consequences of that are a matter of speculation. The important aspect is whether or not the court or anyone else would be able to find a way in which, in the scenario that Section 1383 does not bite, that you could still apply Section 1389A, because it was always the intention of Parliament to give a 6-month backstop, and that can be shown by Section 139. But in effect, what I'm being asked to do is to provide an answer to the problem that's created by the wording of Section 1383. And I only push that insofar as the order itself is regular. Now, if I'm right on that, if you were to set aside that order, then the court would be making exactly the same Section 138 order. It wouldn't make the 4-week provision because it wouldn't arise. It was exactly the same scenario. If I'm wrong on that,
Would the court have jurisdiction? I haven't quite understood that. Would the court have jurisdiction if the order is regular to grant relief against forfeiture? You were making a distinction before between automatic relief under Section 138, discretionary relief under other provisions, or possibly an inherent equitable jurisdiction, taking place as far as the High Court is concerned. And the point you were making very forcibly was you can't, of course, there's no relief as such under 138, it's an automatic consequence of the statutory code. Now, I thought you said in answer to the question that if we're outside Section 138, as you say we are, then there is no jurisdiction to grant relief, either under Section 138 or anything else.
And it-
at least so far as the county court is concerned.
and it follows.
That's your position.
That is, but I acknowledge that produces.
And then,
That's
sorry,
what I'm
then-
putting.
then just follow that one through. If the county court has no jurisdiction to grant relief, either under 138 or by some other route because the case is outside 138, then by definition there cannot be successive trial for the tenant because there's nothing the tenant can ask the court to do. That will be the consequence of your argument, wouldn't it?
Yes.
Right. So what I was dictating to you was that if it was if you succeed on your point 1, then you're not within 138. You're not within 1383, and the consequence of that is there's no possibility of relief under 138 or elsewhere. That's the point my lord just put to you.
Yes, my lord.
Right.
Well, that's a very understandable.
I understand
Position.
that position.
But when turning to the oddity of the way in which the Act is worded, in Forsaloo, the way they interpreted that was to say that 138, that trial was somehow different, and they had that bite at the 138 3 stage, but it may be an answer to have that merely bite at 1389A. Because I'm not, and the appellant's not interested in depriving a tenant from any relief from forfeiture. It is the bit that we are concerned with is depriving the tenant from the automatic relief from forfeiture without the other circumstances being considered.
So I'm trying to relate this to 39.35. What I think you're saying is you've got to draw. You don't. I think you're saying yes. You accept the logical position is that if you succeed on the jurisdiction point, it's a regular order and you're not within 1383, and therefore you're outside the whole regime for relief from forfeiture within the act or outside. I understand the logic of that. Now you're saying, which is perfectly fine, you don't need to go that far. I understand what you're saying now.
Yes.
You don't need to go that far because you could accept that there could be, on a particular interpretation of 1389A, whatever its strict wording may say, the court may say, yeah, but somehow or other you can still use that. So even though you have a regular order within 1383, which your order is now, you're not going to, on this application before this court, going to say, well, you're outside everything. You could envisage a situation of the possibility of the court interpreting 9A, so that would apply.
Yes,
Right.
it's the chucking the baby out of the bathwater.
All right, that's fine. So but the fact of the matter is, so if you're within 9A, you're saying, so that's how I understand this, you're saying, well, if you set aside the order, the most that you'd get is an application under 9A. Is that right? And that would depend on the discretion of the court in all the circumstances.
Yes.
Now, just pausing there, if that's right, so we get this, why isn't the possibility of the why isn't the tenant here, former tenant, in a position to say, all right, well, even if the court was thrown back on a general discretion, if I throw everything in, I would have a reasonable prospect of successfully getting relief from forfeiture under 9A.
Because 9A is only triggered after possession is obtained.
But possession
So-
has been obtained.
So, yes, but 9A doesn't arise at the first hearing.
No, but we're talking about now. There's an application now to set aside for an application now to set aside the original order on the basis, on your hypothesis, of a 9A application. The possession has
Yes.
been obtained.
Yes, it has, and that could be considered, and that could have been considered at the time.
No, but why I'm sorry if I'm being misled here, but you're saying your drawback position is, yes, we don't mind them making an application now under 9A.
No, sorry, we didn't mind them or wouldn't have objected to them making an application back in.
Yes, well, they weren't there. So this is an application under CPR 39.3 because they weren't at the hearing.
Yes, but
And so they now want to, let's assume they now want to say we want to set it aside so we can raise a relief from forfeiture under 9A.
But my lord, that's explained by the tactical reasoning behind, in my submission, the decision they took. When they applied,
Yes.
then if I'm right that by hook or by crook they could have made an application by section 1389A, they were in time to make that application at the same time as they made the application to set aside. The reason why it wasn't in their interest to make a section 1389A application was it would have entailed the exercise of the court's discretion and they could have looked at the landlord's interests, how the position had changed, and everything in the round. What they were seeking by this whole argument of its success, therefore you completely reset the clock, is the mandatory order under section 1383, where the court no longer has any discretion, they automatically get their tenancy back.
In making the application under 9A, we would have to ignore the words the making of an order under subsection 3.
Yeah,
There hasn't been such an order.
I would ignore the word subsection 3, just the making of an order, because that would then have it comply with section 139. And in order to give it efficacy, it would require that to be applied. But the way in which it's being put is they want to ditch that discretion. And then that comes down to the irony, which is that, and we haven't moved on to whether it's Forster-Lumbini or whether it's Findlay, but the irony is that under Findlay, the court recognised that there would still have to be an exercise of discretion. So in fact, the end result of His Honour Judge Luber's decision is that they were in no better position than if they had made an application under section 1389A in the first place. And what I'm urging upon the court is that in effect it will open the floodgates. And this is the first time that any of us have been able to find any reported cases. It's the first time that the Findlay situation has been applied to a section 1389A case.
Can I just understand that the last point you made? You said that as a result of Judge Luber's decision, they're no better off than they would have been if they'd made an application under subsection 9A.
Yes.
And why did you appeal against that decision if you say that going under 9A is exactly what they should have done, and they're in no better position than if they had done?
Because it was wrong in principle. The decision would have an effect in costs,
Right.
and they would effectively be using the CPR to recreate 1389A. And that's exactly what happened in Findlay as well. That they did exactly the same exercise of discretion was still afforded as to whether or not the order should be set aside based upon the change in circumstances.
Well, got this. I think we're dealing, all these arguments we're now dealing with are on the basis, I think we've got to the stage where we're dealing with the basis that all these questions really only arise, I think you're saying, on this drawn back position that somehow or other 1389A applies, because you've already dealt with it, the logic of your primary position, which is they can't succeed because they're simply outside the act altogether. I think we've established that your primary logical position is if you succeed on the jurisdiction point, they're outside any form of relief at all. That's your primary logical position, but you draw back from that. And you say then there might be something under 9A.
Yes, my Lord.
If I haven't understand that, I'm trying to understand exactly the submission.
But my Lord, before the skeleton argument of my learned friend and the nullity point being raised,
Yes.
parties were proceeding on the basis that the order was regular and that section 13 and the rest of the provisions of section 138, so from 4 to 9A, all applied.
I know, but trouble is that now we've seen the jurisdiction point, we can see and we've seen how you argue the jurisdiction point.
But
You're taking the logic of that.
that's the response to the argument on the jurisdiction point.
Yes.
But there's also the question, when giving permission to raise a point not raised below, one of the considerations is that it cannot be compensated in costs. Now, if on the basis before the nullity point was raised, that you would have found in our favour of the interpretation that an order made at the return date cannot be considered a success. If you're with us on that, then that will have a significant impact upon the cost consequences.
Right, if you can argue that on the cost, I understand what you're saying. That's a cost point. We haven't quite got to the cost yet. We're still dealing with the substantive points on the appeal. I understand exactly what you're saying just now, but I'm just trying to deal with the substantive merits of the appeal. Now that we've seen the way you want to argue your ground one, their ground one. So I just wonder. So let's leave aside your cost point, which I do understand. Yeah. Do understand? But I'm right in thinking. I'm still trying to understand about this 9A point, where you say, let's assume for the moment that despite, as my lord has pointed out, the express wording of 9A and the reference of making you can use 9A. So the question is, if we look now at the criteria under 39(3)(b), you can look at the criteria there for this, because that's what they're applying for. Have they acted promptly when they found out the court had exercised its power to strike out? I don't think you're taking a point about that.
We took a point below, but I'm not repeating it.
Was there a good reason for not attending trial? You're not taking a point.
No, we agreed to that.
So the only question then left is in relation to this potential 9A point, which they didn't raise at the trial because they weren't there, which is why they're making their application to set aside the order so they can raise it, is whether they've got a reasonable prospect of success at the trial. And what I've been putting to you, basically, is, well, at the trial, why shouldn't they have the opportunity now of saying, if we go back again, instead of having that order, which on this hypothesis is a regular order, which is an immediate order for possession, we can raise all sorts of other issues. Can't go into them now, but we can raise all sorts of other issues, including, I would say, the ability to pay the rent, but it doesn't really matter. There's nothing jurisdictionally against that, is there? Why do you say they would have no reasonable prospect of success under 9A?
Well, my lord, it's always been ruled that the other points aren't to be considered.
Not for us.
So we've always argued that if they had other issues, such as non-service, waiver, etc., that would have given a basis, if they were genuine, that would have given a basis to set aside the order. That would absolutely satisfy the question of success, because there would then have to be a trial. It wouldn't then be decided at the return date hearing. Directions would be given, and there would be a trial of those issues, if they were considered genuine.
Yes.
What this situation arises is either, forgetting the nullity point, either I'm right on the form of order, or if I'm wrong on the form of order, then you have an order made under section 1383 as if that very first hearing, as if that return day hearing is a trial.
We've dealt with that.
But it's that success that one has to look at. Section 1389A doesn't even come into the frame at that stage. That only comes into the frame after possession is taken. And the only point that I'm making on that is that once possession is taken, you then have this discretionary power under 1389A. That's got nothing to do with trial in terms of the order that they're applying to have set aside. That is a later consequence. What we're looking at in terms of success is the very, very limited question as to whether the
They have-
automatic
they-
order that's
they
made.
Have, they have taken possession.
Yes, we have taken possession.
Yes.
And 1389A then arises if we've taken possession,
Yes.
and so they should have made the application under section 1389A, but they haven't.
But, I mean, do you say that the application under 1389A, if made, would have been unarguable?
That's the judgment answer.
No.
No, they would have had reasonable prospects of success in that, wouldn't
If an application had been made under 1389A,
they? Yes.
they would have, they would have had an arguable case
Right.
under 1389A.
As a result of Judge Luber's decision, you say, they are now in the same position as if they had made an application under 1389A. So why doesn't the same apply? They have a reasonable prospect of success at trial.
Because that would involve this Court of Appeal sanctioning an application for set-aside rather than actually saying to a party, you had the provision under 1389A, you should have made the application under 1389A. And in my submission, it's an absurdity that where you have a statutory provision, that you don't make the application under the statutory provision, you make the application under a highly convoluted interpretation of the rules of court. And the court earlier today, when talking about nullity, pointed out that there is a difference between the rules of the court and the operation of statute. They had the opportunity, they were in plenty of time when they made their application set aside. They made, on our case, the wrong application. And the reason why we believe they made the wrong application is that they did not believe that this was going to be a case where there would be an exercise of discretion of the court, or the 1389A would be recreated in a different
All
form.
right, can I just ask you this question? Maybe it's even simpler than that. They haven't yet made an application under section 1389A.
No, unless you accept my learned friend seemed to touch in his submissions that somehow, impliedly, the application for set-aside included an application under section 1389A. But I've not heard how he expands that.
But from your perspective, you say they haven't yet made it.
They haven't yet made it.
1389A is limited to an application within 6 months of the date on which the lessor recovers possession. So if they had to make it, if we were to set aside, if we were allowed the application to go ahead, set aside the judgment, is that right? Set aside the judgment, and they could now make an application, it would be outside the time limit.
Well, no, if you set aside the judgment, you would have effectively reset the time limit.
No, but it is within 6 months from the date on which the lessor recovers possession. They recovered possession more than 6 months ago. So if there was an application under 9A that had to be made now, it would be too late.
Yes, it would be too late.
That's what I'm saying.
Yes.
So isn't the short point you've got is that you can't get within 9A anyway if the object is to merely to allow them to make a 9A application because it's too late?
Absolutely.
Right, that I understand that point, and that's quite a straightforward point.
You've got, I mean, presently under Judge Luber's order, he's not set aside the order that was made, has he? He's allowed the appeal, but remitted the application to set aside to a district judge to see whether they should exercise a discretion to set aside the possession order. Now, what discretion was Judge Luber thinking he was remitting to the...
He was following the Findlay example, which was that the court wasn't in those circumstances compelled to set aside. They could look at other factors such as had the landlord relet the property.
Right.
So, in effect, Findlay and his own Judge Luber accepted this argument fully, that as they were relying upon Findlay, they had to take the full consequences of Findlay. And so Findlay was, in effect, recreating section 138(9)A for the set-aside application. And we say that's a nonsense to use the CPR to recreate a statutory provision that they should have applied for in the first place. and it wasn't put in the alternative. There was some reference to section 138 in a witness statement, but it wasn't part of the application.
Well, I think I think what the case was doing was simply deciding the question of principle as to how you apply 39.3 5 and the as opposed to CPR 3.1 3.2m and 7. And then saying, well, those are the principles. Now go back to another judge to see whether or not there would be a real prospect of success. Isn't that what he was doing? He was simply determining the question of principle, how you apply those two different provisions, how they relate to each other.
Yes, but he was also applying the way in which Findlay said it should be dealt with, which is that once you've deemed that there could be a success by opening up the time limits on
Yes.
relief from forfeiture,
Yes.
you could then look at all the surrounding circumstances, including had the landlord relet the property. And so in Findlay, the Court of Appeal was dealing with a situation under the Housing Act where they didn't have the equivalent of 1389A, and once possession was taken, that was it.
Stripping your arguments down to the bare minimum here, so you're stripping them right down. You've either got a situation where you lose on the jurisdiction point and you accept on that footing you're not within 39.3 at all. The order simply nullity or set aside, or it's irregular set aside. There's no discretion involved in that, apart from the discretion. If you succeed in establishing that it's a regular judgment and isn't within 39.3, nonetheless, the only other recourse they've got, you could think of, is under 9A. And on 9A, they haven't yet made an application under 9A. They're out of time for doing so. And on both of those grounds, the appeal should succeed.
Yes.
I'm trying to strip it down to its bare minimum. That is the bare minimum, isn't it?
It is.
Right, I understand that. And I think what you're saying is that's the bare minimum, and the vice of Judge Luber's decision, in any event, apart from the fact that it contravenes that analysis, the vice of it is that he is using 39.3, which actually doesn't, where there's plainly no prospect, is that he's using it to recreate a 9A possibility where there's never been an application under 9A.
Yes.
Now, has that encapsulated the essence of your points?
Absolutely, and that's because he takes it from Findlay, which does the same thing in relation to the Housing Act.
Is there anything else?
If I may just very, very briefly, my lord, it's whether force lieu applies or Findlay.
Yes.
In my submission, force lieu can be distinguished. Findlay in itself distinguished it by saying it was very unusual facts. It's not the same as the situation that we have here. And there was a very, very small amount of rent arrears. And in essence,
So force lieu can be distinguished.
it can be distinguished.
On what basis then? I mean, just apart from the small amount of rent, is there any other reason to distinguish it?
Well, in terms of the way in which the appeal is put, if you went with force lieu, you'd have a completely different consideration, and that would require a great deal of new evidence as to the discretion of the court.
Surely the point in force lux was that Mr. Binney was standing to lose a valuable capital asset for a relatively small amount of money. And in Findlay, Mr. Findlay was a secure tenant under a tenancy with no asset value at all. Whereas in our case, Mrs. Martin has an asset in the shape of the long lease of the flat, which she just paid £60-something thousand extended, and she stands to lose that for a sum of money which is considerably less than the value of the flat. I mean, that's
But then this case is very similar to the Gibbs situation, where in Gibbs they lost a very valuable flat on the basis.
well, that may be, but that was for completely different reasons.
Well, it may be that this ends up being a Gibbs case, depending on.
Well, but at the moment you're saying that we should distinguish Forslux and apply Findlay. And my Lord Justice McComb asked you, apart from the arrears, what's the distinction? And I've suggested there might be a distinction between Forslux, with the loss of the capital asset on the one hand, and Findlay, where he stood to lose a secure tenancy on the other.
My suggestion is there wasn't much to distinguish this case from Forslux, apart from the amount of the rent.
My submission on that would be that whether it be Forslux or Findlay, they would both be used in this context to undermine the statutory regime.
It seems to me that Forslux is so close to these facts, and Findlay is a different case of a secure tenancy with different statutory provisions applying. It's the distinction between this case and Forslux that I can't see. I'm not worried about Findlay, which seems to me to be a rather different sort of case. Or have I missed a point there?
Well,
My question is, what's the distinction between this case and Forslux, except for some discrepancy of £1,000 worth of rent compared to £12,000 worth of rent?
well,
Is there any?
the difference between this case and Forslux is, and it's set out at paragraph 28 of my main skeleton, and it's paragraph 57, where Mr. Justice Warren stated, Mr. Binney had a real prospect of successfully defending the claim were the possession order to be set aside. I agree. The claim for relief for forfeiture was, I consider, compelling, given the comparatively small amount of money outstanding, which Mr. Binney was able and willing to pay, and the consequences of forfeiture for Mr. Binney, namely the loss of the lease, a valuable lease at a ground rent with 94 years then left to run.
I.e. the facts of this case, apart from the distinction of the amount of rent.
Well, except for the fact that, it's clear there that Mr. Justice Warren believed that there would be some element of discretion afforded by saying that the claim for relief for forfeiture I consider was compelling, rather than in the circumstance of this case, where the order, irrespective, wouldn't be a claim for relief for forfeiture, it would be an automatic order.
Doesn't that make it more compelling?
No, because
It's not even more than compelling, it's compulsory.
it's compulsory, but it comes down to the discretion point. He considered that there was an exercise of a discretion there, whereas here, and so the court could have made an order other than the order that was made, and I don't know whether he was addressed on this or not, but the point doesn't seem to have been raised, or he doesn't seem to have considered the point, that actually under section 1383, or section 138 generally, the order would be mandatory, and there would be no discretion.
Well, I'm not sure that Forslux and Binney was a 138 case, because there was a section 146 notice, so the service charges may not have been reserved as rent.
I think you were,
From
actually, I think you were.
paragraph 4 and 5 says he was in arrear with ground rent and charges, but then a 146 notice was served, so
And
it may not be reserved as rent.
my lord, I'm grateful for that, because also that gives a reason why Findlay is more appropriate, because in Findlay it was again dealing with an automatic function of the court, and where the statutory time was cut off by the possession. And here we're dealing with automatic functions of the court.
But if it hadn't been observed as rent, why did Mr Justice Warren in paragraph 45, which we looked at this morning, deal with section 138 at all? It wouldn't have arisen if it was not observed as rent case, would it? Maybe I'm missing something.
Well,
Remember the passage we looked at, and
yes.
you cited it to us, and we thought it might be rather against you on a certain point, but it's a discussion there as to section 138, which, as I understand it, is a case that is a section that applies for forfeiture of a non-payment of rent. I take my Lord's point, obviously there was a section 146 notice, so...
There's, I'm not wishing to open up another kind of word, but there is a potential lacuna within the wording of section 138 as to whether or not it applies where you're also proceeding under section 146.
Yeah. Are there other breaches of covenant, perhaps? I don't know.
Unless I could be of any further assistance, my lord, I'm acutely aware that I've not given my learned friend very long
Thank you very
to come
much
back.
indeed, Mr. President. Yes. You see the way the case is put now.
I do. A lot of what's happened this afternoon is simply because it is actually quite hard to develop the original ground of appeal without referring to the fact that the order is in the wrong form. You keep getting dragged back to it. But for the purposes of my learned friend's ground of appeal, I want to make it very clear, particularly because he started talking about costs. My position is that the original ground of appeal was also doomed to failure. It's doomed to failure because what it amounts to saying is that an application or a reasonable prospect of obtaining relief from forfeiture isn't a defence and isn't a reasonable prospect of success. And that's just wrong. And it would be wrong however you get it. And perhaps the simplest way to put it is this. I would say that obtaining relief from forfeiture is always success for the tenant. And putting it bluntly, it doesn't matter how you get there. And if you get there by applying to set aside the original order so that you get a new order with a form of relief, you've got relief. And it doesn't matter whether that's some kind of automatic relief, which is inevitable, or discretionary. Relief equals success.
But what about the point, I think I put to Mr. Senate, that all that the landlord could expect if you started the matter de novo was a section 1383 order. That's the best. That would be success for him too, because he can't succeed any other way. He can't get anything else. However well he argues and presents his case, that's all he's ever going to get. And that's what you're asking to put in its place now.
Well, there are two potential answers to that. First of all, that in a sense isn't success because, as Lord Justice Lewison said, it's a possession claim. You've been brought. You didn't have to. You could just sue for. You could just issue a debt claim if you wanted. You could issue a stat demand for non-payment of the rent. You chose to sue for forfeiture, which is a nuclear weapon in the law, and you don't get it. You don't terminate the lease. Therefore, you haven't succeeded. That's point one. Point two is that the question is not whether the landlord succeeded. The question for 39.35 is whether the applicant is going to have a reasonable prospect of success. So perhaps a way to test it, let's assume there was a claim and a cross-claim, and the claim is for £10,000 and the cross-claim from the other side, the counterclaim, is for £11,000. Due to some disaster, the tenant fails to turn up, or the defendant fails to turn up at trial, so the landlord gets judgment for £10,000, which he's entitled to. Surely the tenant could say, well, hang on, but had I turned up at trial, I would have got judgment for £11,000, and therefore I would have been successful. You can't, I would respectfully suggest, say that they would be prevented from applying under 39.5 simply because part of the claim on the other side would be a good one and they could therefore claim to be successful as well.
It's rather boring that 1383 talks about the court at trial being satisfied that the lessor is entitled to enforce the right of possession, and that's what he's seeking to vindicate. And therefore, on one version of events, he's succeeded, and he can't do any better than that. But he's obliged to say, well, I'm sorry, I've succeeded, but I have to accept that the order you get is a time to pay some money. Otherwise, I mean, you-
In the context of the application, though, what's happened is that this.
I see your side of it too, but I didn't see how they can succeed more than they would do under getting an order under 1383.
Your Lordship is right. The best they can obtain is a 1383 order.
But your point is that they didn't get a 1383
Yeah,
order. They got something else, some other form of order,
Yes.
and it's success of trial in relation to that order, which you want to set aside. Because we're on this part of the case, as my Lord Master Rolson says, we are assuming that you're not entitled to have the order set aside as of right.
Yeah.
So the question then is, if you succeed in varying the order as made, so as to give your client time to pay, does that count as success? So we're not measuring it anymore against 138 because we're outside 138. We're measuring it against what the landlord in fact got.
Yeah. There are two levels to it. Yes, that is it, because in fact they got an order under 1383, which on this artificial hypothesis is regular. And on this artificial hypothesis, therefore, getting an actual 1383 order is significantly better as a result, and therefore it is obvious that the tenant would have success on that basis. The reason I framed the...
Touche, Mr. Rainey. I'll back off in praise of my
Well,
Lord's point.
Your Lordship is right, because the reason I framed and put that paragraph 21, which was the basis on which I was arguing, which is artificial, that's taken from Lady Justice Asplin's order, defining the ground of appeal. And the ground of appeal, which is supposed to be the general importance one, is simply is the prospect of getting relief under 1383 a prospect of success, which I took to be a general proposition. And because, of course, that argument could arise in a number of differing circumstances.
The difficulty that we're in is we're now considering the original grounds of appeal in an artificial context. So we're getting into and to say, well, let's look at the original grounds of appeal, I'm afraid is really, waving the flag long after the battle's been lost or whatever it may be.
I know, and that's my fault.
That is why we're in this great difficulty. But I think where we've got to, I think what you need to do is from my perspective, my lords may think differently, but from my perspective, what I'd like you to do is to confront the arguments that are made by Mr. Sinnott on the hypothesis which is the only one he can run at the moment, which is on the hypothesis that you failed.
Yes, I do understand.
On your jurisdiction point. Now he says that at that point, there's no point in giving you leave to do anything because you're completely outside the statutory scheme. And there's nothing outside. You're not within the statutory scheme, and there's nothing outside the statutory scheme. That's his first point. He then says, well, he realises that's a bit extreme. So he says, yeah, but look, at most you can get 9A under some sort of peculiar construction of it, but you never made an application under 9A, and you're now too late to do so. So you're out there as well. That's what it comes down to, I think, for my purpose, at the end of the day. And I think you need to just deal with those points.
First point is, with the greatest respect to learned friend, every piece of that argument is wrong. So that's the first point. It's just completely wrong, and there clearly is jurisdiction to grant relief. Second point is that section 138 9A, he keeps referring to that because it suits his client, but section 138 9A is only necessary because of section 1387, which I did refer you to this morning, Lords, and it's section 1387 which says that it says that if an order is made in the form of section 1383, then the tenant and the time limit expires, then the tenant is barred from all relief. If 1383 doesn't apply, there is no bar on all relief. And if there is no 1383 order and no jurisdiction under 1383, then it follows that section 1387 doesn't apply either. So there is no, quote, bar on all relief. And if the argument is then said, oh, well, the county court doesn't actually have any jurisdiction, then actually there's a fallback position, which I hesitate to mention, which is I'd simply say, fine, transfer it to the High Court. which has jurisdiction under section 38, the old equitable jurisdiction to relief for non-payment of rent. It is only section 1387 which prevents that kind of transfer, because the De Palma case, which I referred to and you don't have, but there's a case called De Palma in Victoria Square in 1985, said you couldn't transfer it up to the High Court because 1387 blocked the High Court's rights.
Right, so what do you say about that?
Well, 1387 wouldn't apply on the learned friend's hypothesis because he's already effectively destroyed the statutory scheme. He said there isn't, 1383 doesn't apply. If there's no,
I see what you're saying.
no 1383
You can't
order,
get around 1387 by saying, okay, transfer to the High Court. But if 1387, if you're not within 1387 at all, because you're not within 1383, then there's no problem, you say, in transferring.
I could transfer it. That would be the logical conclusion of this excursion. But in my submission, the simple answer to all of this is that on the hypothesis that the order which was made was regular, nevertheless, regular orders can be set aside under section 39.3, rule 39.3.
Yes.
And we know that we've satisfied two of the three hurdles, namely promptness and good reason for not attending.
Yes.
And then the third reason is simply to say, well, I have effectively lost the opportunity which I was supposed to have to get an order for relief. And for this purpose, one way or another, and if it had to be to go to the district judge to say, well, the county court, it's turned out, doesn't have a relief jurisdiction, it should be transferred, that would be success. And Findlay is a very good authority for saying that that kind of argument is a good one, because in Findlay it was said, well, an application sort of after the event under section 85 of the Housing Act, that could count as success, because you're in the odd CPR.
And what jurisdiction is the High Court exercising there at this late stage?
It's the High Court retains the old equitable jurisdiction to relieve against non-payment of rent, which is currently it's preserved but not given by section 38 of the County Courts Act. Sorry, the Senior Courts Act of 1981.
And what that's just discretionary in all the circumstances.
Well, actually, there are two points which I should say. The first is it wasn't really discretionary in the sense that almost inevitably the courts of equity gave relief, provided, but there was a time limit issue which my Lord Justice Lewison discusses in the Gibbs and Lakeside case as to whether there isn't a strict time limit, but there's a suggestion in my Lord's judgment that you should at least have an eye to the statutory time limits. 6 months. There is a case called Pineport and Grange Glen where the Chief Master gave it, I think, after 16 months, although my Lord Justice Lewison suggested that might be wrong. It's more flexible. I think I could safely say that. But the short point I submit about this, and the fundamental one, if you like, the thing which Lady Justice Aspelin was aiming at when giving the permission to appeal is getting relief from forfeiture when you do owe the money. Is that success? And in very broad terms, the answer in my submission is clearly yes. And that's in effect what Judge Luber ruled, and he was right. And
but it is as simple as that, because if we're assuming a case which is, if we're now assuming a case within section 138, we're assuming that section 138 applies, then we're getting around it, but it's true to say that if you don't pay before the these 5 clear days before the return date, then the truth of the matter is that the order that has to be granted is that in the form of 1383.
yes.
And you can't really describe that as relief from forfeiture. The landlord has got an order for possession. You may avoid the forfeiture by paying, but the landlord has succeeded in getting possession. How do you get round that? That's not really relief from forfeiture, is it? It's only relief from forfeiture you actually pay up within the period of time, but the order doesn't give you relief from forfeiture, does it?
Well, it does, in my submission, that is a relief from forfeiture order. An order which says possession will be given unless you pay.
But again, we're getting, I'm now ignoring, because in order to get into this discussion, you have to ignore the argument about jurisdiction.
Yes.
You have to ignore that completely to get into this.
Yes.
And I think the point that's been made is, well, you know, if you were in a case within 1383, then the order the court ought to have made and would normally make would be one complying with 1383.
Yes.
And that's all you're going to get. 1383 order. Why? I mean, you can say that's success, but why is that success if that is? I think we're going around circles. What my lord said, that's all that could be given. Now, on the facts of this case, they didn't comply with 1383. So I suppose you can certainly say in this case, if you ignore completely the argument about jurisdiction, the effect of going back is you get a better order.
Yes.
You can say that. So you can cut through the whole of this on this kind of very artificial basis by ignoring the jurisdiction argument and saying, look, the fact of the matter is they got this type of order, this other type of order in accordance with 1383 is a better order. Whether you call it relief from fraud doesn't really matter. It's a better order from the tenant's perspective. And to the extent that they get a better order and the landlord was going for an absolute order, that's success. I think that's how you have to put it.
Well, let me make it clear. Let's assume that you had a case where the landlord or the district judge put the order into the right form, but nevertheless there was a perfectly good reason for the lessee not having turned up. They didn't know about it, and they found out very promptly, and they applied promptly, and they applied to set aside the order. And they might want to apply, because you might say, well, in those circumstances, wouldn't they simply apply for an extension of time under 1384? But let's assume that the landlord had done what this landlord had done, and precipitately, as I keep putting it, granted a new lease. So the lessee might, even though they found out promptly, and there was a 1383 order, they might want to apply to set it aside. And the question would then arise, well, if they got the order set aside under CPR 39, as applied by analogy, and the consequence was that they got a new order, same form but with different time limits, would that not be success? I would say yes, it would be. They'd obtained something significantly better than the previous situation. And again, I would say that this is, there's no, as my learned friend keeps saying, this is all cutting across statutory time limits. It isn't, because section 1387 specifically says that once your time limit has expired, it says the order shall be enforceable, and so long as the order remains unreversed. The statute itself supposes that tenants may come along to reverse the 1383 order. Now, it may be, of course, that they are going to reverse it. You might say to me, well, they're going to reverse it on substantive grounds. For instance, there was never a forfeiture in the first place. But that can't be what this means, because what it goes on to say, it says, so long as the order remains unreversed, the lessee is barred from all relief from forfeiture. Well, if, for instance, they had an actual absolute defence, such that there was no forfeiture at all, they don't need relief. They just need to reverse the order. So what section 1387 is specifically contemplating is that a tenant who doesn't have a defence, but who might want relief, can come along and get the original order reversed.
You say relief in subsection 7 is confined to relief against forfeiture, do you? Or is it any remedy at all that's properly described as relief?
In my submission, because it says subject to subsection 8 and 9a, it's barred from all relief. Well, 8 is an extension of time, and 9a is relief from forfeiture.
Yeah.
So, in my submission, it doesn't mean relief in the sense of the relief sought in the prayer. It means relief from forfeiture. So, I say it is implicit in this. And I have to say, I start from the proposition that, generally speaking, a claim to relief from forfeiture, the old equitable jurisdiction, it's a counterclaim, it's an equitable set-off. I've adopted into my argument in the supplemental skeleton the Old Bridge case and Sambrin, which should have been in the original, and my Lord Justice Lewison drew to the parties' attention, which say that relief from forfeiture is a defence. So that's the general proposition. And I am putting my submissions on the basis what my learned friend has to satisfy the court is that because this has ended up in a statute, somehow we've come out of the general proposition that relief from forfeiture is a defence. And I do not accept that.
Well, that's because when the hypothesis we're now looking at, we've already dealt with the hypothesis of the facts of this case, ignoring the jurisdictional argument, which is they get an order and therefore the landlord's asking for an order for immediate possession. If you replace that order with one in accordance with 1383, you've done well, you've done better.
Yes,
so that's a success in that sense, in a realistic sense. But you're now under a different hypothesis, which isn't the facts of this case, and nor is it concerned with the original argument about jurisdiction, which is in a case where there was an order in accordance with 1383, but the tenant didn't turn up for whatever reason, on what basis could it apply in the circumstance of the present case? And say, I'm entitled, I'd have a good chance of success at the trial. That's the hypothesis we're now looking at, as I understand it.
Yes.
And that is what, crucially, Mr. Essent is focusing on when he says, well, the most you could ever get, was another order under 1383, but with a different time period. And that's not a success, because that's all the landlord's entitled to, and that's what they got, and that's what you're going to get again. And I'm not sure that you've really answered that point, to be honest.
Well, I hope that I have. My submission is that my learned friend is simply wrong about that. If you
What is about that?
about not having succeeded, my submission is this: the point of the time limits and so on is you're supposed to get an order which you can pay. Now, if the tenant is the victim, if you like, of a completely regular order which is properly served, and they don't have a good excuse for not turning up, they haven't applied promptly or whatever, they're stuck with the order. And it's their loss that they didn't pay up within the time. But if they never knew about the order, then they never had the opportunity to pay within the time limit which Parliament had set, and they have lost, if you like, the ability to get relief as of right. And there may be things which have happened, for instance, the landlord who relets. So they are, what you might say is, at that point, they are 15 love down. If they can go back and they say, no, good reason for not turning up, prompt application, what I'm entitled to is the order in the statutory form, and I will then pay, or indeed I will tender the money beforehand, so we never even need to make that order. I would submit that that is success. The tenant's position is improved, and the landlord won't get possession.
But your point, I think, is that success equates to something which, from the applicant's point of view, is significantly better than the current order.
Yes.
But is that, so my question, that's correct, is that what you're saying?
Yes.
Is that what it's talking about? That's I think, if that's the test, then you're right. But I think the question is that the test under 38.3b, where 38.35, where 39.35, where it says has a reasonable prospect of success at the trial. Now, there it's talking about success at the trial, so it's the trial of the landlord's claim.
The trial which is to come, yes.
Trial which is to the claim. And I think I'm not sure that by saying, oh, well, I'll be better off than I am now, under the existing order, is the correct test for that. The question is whether or not that you have a prospect of succeeding against the landlord in the landlord's claim at the trial. And that's the point that's been advanced by Mr. Sinnott, because he says, no, you're not. What you have to say for that, it seems to me, is what I was trying to put forward, and I think you have adopted, which is to say, well, if there's a real prospect you could pay the money in advance for a profit, so if the judge never makes an order for possession at all, then I think that would be a prospect of success of a trial at the moment. I'm not sure whether you're saying the mere fact that you get a longer period than you've got under the existing order is a success, because I think Mr. Sitt would say, no, but that's still the same order. The landlord still gets the only order that the landlord can get, and the tenant has to make, which is an order not less than for possession, but with not less than a certain period of time.
Yes, but well, the trouble, there are two aspects of that. I mean, the first is that let's assume that it is the tenant, there's an order being made in the form of 1383, and it was a 4-week order and the time limit is gone, but the tenant's applied promptly. Well, subject to the tenant's application, the tenant will be barred from all relief by subsection 7. And if they get the order reversed, to use the words of subsection 7, they will be unbarred from all relief. So there's, I would submit, a form of success. And the second...
But that's still comparing the position with the present position, as opposed to comparing it with the landlord's rights under the original action. It's still, I mean, I think you're home and dry if you're correct in saying the comparison you're making was with the existing position of the tenant, as opposed to the position they would be in if the order was taken away. But I'm taking time to press you, is saying, well, that may not, doesn't seem to be at the moment to be the test.
The second point the first point is I would respectfully submit that the test is to be viewed from the point of view of the applicant, the person who is trying to set aside the order. And I do repeat that I would submit the counterclaim argument.
I suppose you might say that the CPR rule is designed to deal with a case where the tenant is in real trouble, or the person who's subject to the judgment is in trouble under it, and therefore you've got to gauge the prospect of the trial that he might get against the order to which he's already subject, because that's the game you're playing when you get here, because you're going to, although respectively, at the prospect of the new trial, you're going to get a lot better order than the one you're subject to. Is that it?
I do say that, and that elides into the point which I was going to make, which is that although we keep looking at CPR 39.35, one must not lose sight of the fact it is being applied, if at all, by analogy only, which is the Findlay point.
Yes.
And in Findlay, Lady Justice Ardner, paragraph 24, does say, because you're taking it in effect out of context and applying it to the code under CPR 55, you have to apply the concept of successive trial with less rigour. And it can include things like a tenant who gets an order suspended. And what's the difference, one might say, between a possession order which is outright or suspended? Well, not a huge amount, one might think.
What would be, and it's far away from our case, but what would be the position if somebody brought a claim for unliquidated damages in the county court, had a trial, got the damages assessed at, let's say, £50,000, and an applicant says, well, if I'd been there, those damages wouldn't have been anything like that. They would have only been £5,000. Would that count as success at trial?
Yes. In my submission, it would.
But you get there. I think what you're saying is you get there through is it CPR 3.1 is 2M, and you're applying this by analogy. I think that's how you have to do something like that, because on the precise wording, it seems on the precise wording of 39.5, it's looking on its strict wording at the success vis-à-vis the landlord, as opposed to just improving your position from the present one under the existing order. But I'm writing that, that's how you say it's an analogy, and you have to apply it in an appropriate way.
It's definitely analogy, because Forslux and Binney says that CPR 55 isn't a trial, therefore 39.5 doesn't apply. Findlay, and that's the Forslux case, it's a general discretion. Findlay then came along and said, well, yes, but it's very similar to a trial. I'm paraphrasing. It's similar to a trial, and therefore you ought to apply 39.5 by analogy. But, as Lady Justice Ardern said at paragraph 24, you do have to make it adjustments, in effect. Mutatis mutandis.
That's how you get there.
It is.
Yes.
Could I ask a separate question? When you're not really defending Judge Luber's order entirely, are you? Because he didn't say, well, I'm setting aside for judgment, and you can get a section 138(3) order. He's remitted it to a district judge to decide all sorts of other questions. Or is that what you are defending that order, or aren't you? I'm looking at paragraph 2 of his order.
Yes, he remitted it to the district
And
judge.
you're happy with that, are you? Would you regard that as success here? Is that what the order you want to preserve, or do you want something else?
It depends on which basis I succeed. If I succeed on the basis that the order is a nullity, then I might, or you might feel, my lords, that you could simply say this order has to be set aside because there will be no other answer to which the district judge could come. If I don't succeed, or I don't completely succeed on that, then I can see the argument that there might, or my own friend will say, there is still some element of discretion, and that hasn't been argued out. So on that basis, it would go back to the district judge. But I did say in my skeleton argument that I rather hoped that the judgment of this court, however it is decided, would give the district judge a very clear steer.
And you've not
Okay.
cross-appealed.
We've not cross-appealed, no. We've simply said that Judge Luber's order should stand.
Okay, no, I
But
understand.
I am, to Judge Luber's judgment of paragraph 73, I do say is subject to the nullity point, which wasn't right in front of him, is right. I mean, he said,
This paragraph?
it's page 82p, it's paragraph 73 of his judgment.
Yes.
Because he said, bearing in mind, I consider the question for the Deputy District Judge was whether there was a reasonable prospect of success in the sense of defeating that which CPR 55 is designed to produce, namely an order for possession. It says, as the Hackney and Finlay case shows, the question may be a broader one. Even if the landlord obtains an order for possession, the question is whether the tenant can obtain such succour from the court as will avoid that order for possession causing the loss of the tenancy. In that sense, it seems to me there's a direct read-over from the terms of the Housing Act 1985, as explained by the court in Hackney and Findlay, to the context in sections 1382 and 3 of the 1984 Act. Well, my lord, I do say that that is absolutely right. There is a direct read-over. Success under the Housing Act, obtaining suspensions, etc., is, to use Judge Luber's word, succour for the tenant. And perhaps the way to put it, perhaps that's a more elegant answer, which I should have adopted earlier. It's not, the landlord doesn't get success by getting possession. Success is possession causing the loss of the tenancy. And perhaps that is the key to understanding why relief from forfeiture in some form is success, and is always success for the tenant, because it means the tenant doesn't lose the lease. And if this order, which was made by Deputy District Judge Thomas, is set aside, then whatever may happen in the future, the immediate consequence is that the lease will not have been terminated by a court order. It doesn't undo necessarily the service of proceedings which begin the forfeiture process, but it will restore what's often called the limbo period to the lease. So the possession order, which has currently terminated the lease, will not have terminated the lease. And so therefore, in the words of Judge Luber, there will be a significant improvement in position of my client.
And it might also be a case of saying that success is not a zero-sum game, that just because the tenant is successful doesn't mean the landlord isn't as well, in some respects.
I think I've taken that point in my skeleton argument, which is, it is this point, both parties can be successful. I go back to the point about two parties, each of whom have a claim against the other. The fact that one side doesn't turn up, so the other wins on their claim, it doesn't mean the other side doesn't win or hasn't got a reasonable prospect of success if they can restore their cross-claim, which was no doubt dismissed for non-appearance, and obtain a better result. That, in my submission, is also success. So
You haven't obtained a better, again back to your point, that the fact that if you set aside the order, and you get a fresh order, in this hypothesis in the same form with different payment dates,
that would be a better result.
well,
because the original order would have terminated the lease.
But I think they'd have to give you a payment date. You have to extend the payment date to whatever to now, I suppose. I don't know, because you have a fresh order, don't you?
Give a fresh 4
Allow you
weeks
to do
minimum.
that. But is it vis-à-vis is it a better order? And you seem to say
Yes.
that what you're looking at is possession which causes the loss of the tenancy, but you won't know whether it causes the loss of the tenancy until the period's expired. There you're looking at two things: one, the form of the order, and two, what actually is done in consequence of it. So when you're talking, I would have thought, when you're talking about success at the trial, you can't be looking at something which, as it were, happens after the order in the working out of it.
I would put it the other way round. If the current order has, for one reason or another, caused the loss of the tenancy, then the effect of if the relief which is granted on the application, setting aside, etc., if that undoes the loss of the tenancy,
Yeah, well, I understand, but that's going back to the point you made before about it's all analogous. That's really the same. That's really just another elaboration of that point. That if you're going to end up in a better position than you are now, then for this purpose you had a success. That's all. That's just part of that argument.
well, it is. But I think what your lordship was saying is you don't know whether you're really in a better position because you
No, I accept that argument. But what I'm saying is that if that's what you can do, and that's what success means by analogy, I've got no problem at all. I thought you were making yet another point, which is if you can't look at the present position and you're simply comparing the order that was with the new order, that's all. You can somehow take into account in assessing the new order what happens afterwards, i.e. whether the possession is obtained, and that's what I was talking about.
yes, I know you're querying whether that can be one of my points, and yes, I would say that is the case because it's the reasonable prospect of success, and if one has to assume that you're not going to bother getting the order set aside to get a new 4-week order and then not to comply with it, so I would say that is still success.
All right. Anyway, that's fine. I mean, maybe you can. It's sufficient for you to say that under the new order, you've got an opportunity to pay which you didn't have under the other one, and therefore simply that on its own is sufficient for terms of success for your purpose. I think that's an easier way of putting it.
That is, and that deals with the actual ground on which Lady Justice Aspin gave permission to appeal, and that's in effect what Judge Luber is saying, which it comes back to is Section 138, the prospect of getting a 1382 or 3 order, a reasonable prospect of success, and the answer to all of those questions is...
I think you're saying that is a success vis-à-vis it's a success vis-à-vis the landlord in the more strict sense of success at the trial, because you say that you get a relief from forfeiture with which you can comply, whereas the previous one you couldn't.
Yes.
That's the way you put it.
Indeed, yes. And that deals with the broad ground. I mean, as we all know, there is the intermediate position, which is that as a fact, an order which is in the form of 1383 will be significantly advantageous compared to the one which was actually made, regular or not.
Well, perhaps that's a better way, may I suggest, that might be a better way of putting it, or an alternative way of putting it, from success is possession causing the loss of the tenancy. It's simply saying that this has given you a facility by which you can avoid forfeiture, which you couldn't under the original order.
Yes,
Maybe it comes to the same thing, maybe.
yes, but that is, I agree, that is an elegant way of putting it, my Lord, if I may say so.
Anything else?
I don't suppose I have time, but I think those are my main points, and you have, I think, read both sides' skeletons.
Yes, we have. Right, thank you very much. Well, I think, Mr. Sent, you do have a right of reply on this part of the appeal.
My Lord, I'll keep it very short given the timing. My Lord, there's 2 points that I wanted to focus on. Firstly, my Lord came up with a hypothesis that if you found on our point on the jurisdiction and the form of the order,
Yes.
that you may be able to have that set aside so that you could go back and then have a better order made under section 1383. However, if you find it in our favour on the form of the order, then that wouldn't be available, because if it went back, they'd make exactly the same.
I was hypothesising there that we forget entirely about about the point of jurisdiction, and we simply look at the appeal as it was originally.
Indeed. But also, my lord, the difficulty with my learned friend's position that this is some form of success, and I reject the fact that it may be rooted in relief and forfeiture, but it is statutory. It is a statutory automatic provision.
Yes.
But where does it end? So if his general position is that all they have to show is that the tenant or the defendant would be better off than they are now, then what if the court has given a money judgment and there's interest, and in fact the tenant is wanting to reset the clock so they don't have to pay the interest and just the money judgment? What if they wanted to challenge the costs order, and so they wanted to reset the clock so they could do the costs order? Or more pertinently, and this is something that actually the evidence of the respondent that she submitted on her behalf at the original set-aside hearing didn't address in my submission is she said, as of that hearing, ready, willing and able to pay. We don't know what her financial situation was in the time that the order was originally made, when she would have got that 1 month period. So if she had a 1 month period or any time following that, she may not have had the ability to pay. Does it mean that any tenant who couldn't pay at the time of the order, but gets a national lottery win fortuitously, a year later, can apply to the court and say, well, I want you to reset the clock because I can now pay and I would be in a better position? To reduce success to it would be better for me raises the question of when would you ever, if the Section 39 provisions were to apply, when would you ever have a scenario in which a tenant wouldn't be better off? And the tenant, my learned friend said, well, the tenant wouldn't go through all the rigmarole of applying to have it set aside if they didn't have the money to pay. But in effect, without having the money to pay, they haven't got to come to the hearing and prove that they have the finances to pay within the next month. They could come to the hearing and say, well, I didn't know about it. As soon as I found out about it, I applied promptly. Two things which are very difficult to ever, as in this case, and the facts of this case, disprove. And having an order made again is success. It may be exactly the same order, but it is success. They then get
Well, it's
back
not
into the
same
property.
order. It's not the same order, because I was just saying I had exchanged with Mr. Rainley. You'd have a different time period for payment. So it would be a different order in that sense. And the point I think he was maybe accepting, putting it slightly different language than the way I was putting it, but the long and the short of it is that under the order with the new and different regime for payment, you could comply with that, whereas you couldn't comply with the other one.
And in effect, undermining the statutory regime by doing so. Because if a tenant had no ability to pay, they, under this reasoning, would be able to apply to have it set aside and say, well, I'm in a better position because then I've got a month in which to...
But we are assuming they can comply with the other elements of 39.5. That is that there was a good reason why they didn't attend, and that they've applied promptly. So you've got to assume they've got those two.
Yes, and anyone who's not at or not resident in their property without having made any arrangements for their post to be forwarded is going to always satisfy the first. The second, in terms of promptness, well, if they get legal advice they'll make the application promptly. The third is reset the clock. And a wood tenant wouldn't even have to prove that they had the ability to pay. Because as my lord quite rightly
Had
identified,
the ability originally to pay.
had the ability originally to pay, or even had the ability now to pay.
Why would they not have to show that?
Because they would be better off, for my learned friend's argument, by the fact that actually the order that's made is one that doesn't give an immediate order of possession.
No, but they would have to show that it's likely that whatever the period was that was given was one within which they could pay.
Well, except that...
And otherwise they couldn't really show that it was a better order for them.
Well, except that not only would they then get the 4 weeks if the clock was reset, they'd also get the ability to apply for further extensions,
Yes.
and the landlord would have to seek a warrant of possession because they'd be back in the property.
Yes.
And so, actually, they could make the whole thing drag on for much, much longer. The point is that this is simply a device to reset the clock.
Yeah, you've made that point several times.
Yes.
No, I have nothing further to add, my lord. Thank you.
Thank you very much. Well, we're very grateful to both counsel for this interesting case, which raises some important different issues. We will consider our judgments. When you receive the draft judgment or judgments in due course, will you please agree a form of order? Any further submissions, including on costs, will have to be in writing. We won't want any further oral submissions unless we ask for them. We're most grateful.